right, we're going to go ahead and get started. Welcome so much. We're glad to have you joining us today. For those who haven't joined one of our prior webinars, I really want to welcome you on behalf of the lawyers at Dorsey and Whitney, as well as the legal core community. So I am pro bono counsel at Dorsey. I help run our pro bono program, and I also serve on the board for Legal Core, which is a nonprofit that helps connect small business owners, minority business owners, and small nonprofits with volunteer lawyers from across Twin Cities law firms. And as part of their services, the lawyers will be bringing their services to you pro bono, so without charge. And we especially want to be able to help you during this time of rebuilding for those that have had damage from civil unrest and from COVID, and it's been a tough spring, and we're here for you. And so the main thing we want you to go away with today is knowing that you're not alone and that we're here to support you, and we really want to help you rebuild so that you can continue to thrive and be an important part of our community. And first of all, I just want to mention that there is a function at the bottom of your screen. You should be able to scroll around and hit more and hit chat, and you can submit a question through the chat function. And I will read those at the end. We'll have a Q&A time period. You also could send me an email. I'll be monitoring my email some. You should have all received an email from me this morning with the PowerPoint. For any of you that are watching this in replay and you have follow-up questions, the slides do include the email addresses for today's presenters as well as my address. And we really do welcome you to reach out with those questions. If it's something that we aren't in a position to assist you with, I'll get you in touch with someone over at Legal Core and we will find someone that can help you. So really do encourage you to have those follow-up questions. And I will be talking to you again at the end. I'm going to turn things over now to Tien Kai and Jocelyn Knoll.
Good afternoon. My name is Jocelyn Knoll. Along with me is my colleague, Tien Kai. I'm the chairperson of Dorsey's Construction and Design Practice Group. I've been practicing law for 28 years, and all 28 of those years has been focused in construction law. Tien?
Yes, good afternoon. My name's Tien Kai. I'm an associate here with Dorsey in Minneapolis, and I also focus on construction litigation.
Today's program is part of the webinar series, Rebuilding Our Communities Strategically, and offering you the legal resources to help your small businesses rebuild and get back on their feet. What I'd like to specifically focus on today are the nuts and bolts of the construction process, and particularly with respect to what you need to do and you need to know with respect to the contracting process and hiring a contractor, negotiating the contract, and making sure that the risks are fairly allocated so you are not exposed to additional risks that could cause you more peril than you've already encountered in recent times. So we want to make sure that we can work with you to help you so that you're protected and that you get the rebuilding work done for the right price and within the contract that you negotiate. So welcome. So our goals today are as set out by Tien.
So we've got a couple of goals, and mostly they all relate to the construction contract. So first, the first goal is understanding and revising the contract and negotiating any changes to that contract. Second, we want to focus on key contract provisions. And these are provisions that Jocelyn and I had put together that are very commonly negotiated, and we call them the top 10 list. The third thing we want to cover is we want to cover best practices in reviewing and revising your construction contracts. And then lastly, we want to cover insurance requirements to make sure that your project is secure.
And these insurance requirements are not the insurance that some of you may be calling on right now to cover the losses from the vandalism and the fires. Instead, these insurance requirements are requirements that will advise you to include in your construction contracts to protect you if there's problems with that construction later on. So we're talking about two different buckets of insurance protections here. looking at how do you get started here? Any construction process is complicated, as we all know from any type of home improvement projects that we've either undertaken ourselves or hired someone to undertake. And you certainly, as business owners, know that as well. Organization is the key. My recommendation as you start to look forward to your rebuilding efforts is to set up a file. I would recommend, an accordion type file that allows you to set up several sub files, and so that you're keeping, all of the paperwork necessary for example, any financing requirements from either a lender or the insurance company. Another subfile would be mechanics lien waivers. Another subfile would be change orders. Another subfile would be any type of written notices that are required under the contract. Those are the types of things. Schedules, very important. Any insurance certificates given to you by the contractor. All of those items should be kept in this file. And by the time your project's done, that accordion file, depending on the size of the project, should be rather full. The second is with respect to those of you who have insurance and you've made claims to your insurance company for the damage caused by the fires or the other acts. Make sure that you're tracking that separately. There's another Dorsey webinar that's occurred to talk to you about the insurance coverage. But again, make sure that to the extent that you haven't already done so, that you're giving notice to any insurer who may have, an insurance policy that they have to pay out under. So this is not the time to be shy about picking up the phone and giving notice to insurance companies. The worst thing they can do is say no, but you want to make sure that to the extent that there may be coverage anywhere, that you're making a claim under that policy. Then you need to gather your wits about you, and with respect to your construction project, depending on the size, whether it's building out tenant space or rebuilding, an entire new building, ask yourself, do I need an architect? Do I need an architect to design the construction in terms of preparing plans and specifications? Do I need an engineer? Where do I go for that? Make sure if you're hiring any type of professional designer, design professional, if it's an architect or an engineer, make sure that they're licensed. You can go to the licensing board on the website for the state of Minnesota, and you can check to see whether any architect or engineer you might be considering is actually licensed by the state of Minnesota, and architects and engineers are required to be licensed by the state of Minnesota. Next, you need to look at whether you need a construction manager or general contractor, or whether you're going to perform that role yourself. I will say that if you haven't taken on a significant construction project and managed it, this is not the time for you to learn. Instead, you want to make sure that you hire someone who is credible and experienced in commercial construction, not residential construction. Commercial construction, there's a difference. And given the economy that we have now found ourselves in with the pandemic, there are residential contractors who will try to cross over into commercial construction. My advice to you would be, unless you know that person very, very well and feel comfortable that they can make that transition, your project should not be the project where they conquer their learning curve. Hire a commercial general contractor. In the state of Minnesota, commercial general contractors are not required to be licensed. That said, the subcontractors underneath the commercial general contractor, for example, an electrician or a plumber, those people are required to be licensed. So make sure that your subcontractors are licensed, not only in the state, but also within the city of Minneapolis. Looking at how you want to set up your project, there's the traditional delivery method of where an architect would design the project. You would put the project out for what I call bid, obtain several bids, and then award the construction contract to a general contractor or a construction manager at risk, who is the equivalent of a general contractor. That's the traditional way of delivering a project. The other way of delivering a project that's relevant here would be design build, where you would put both the design function and the construction function under one contract, and that way you would only have one contract. The advantage of a design build for you as an owner is that under the traditional method, if you hire an architect, you have one contract with that architect, and that contract is between you and the architect. Then you subsequently enter into a contract with the general contractor, the constructor. That's a separate contract, and that contract is between you and the constructor, the general contractor. There's no contractual relationship at all between the general contractor and the architect. Instead, you find yourself as the pickle in the middle. And the pickle in the middle creates problems, because if there's any deficiencies in the architect's plans that cause the general contractor to incur additional costs, you will ultimately be responsible for those costs and then have to go recover from the architect. You've got enough on your plate. So, unless it's a very simple build out, you should probably think about a design build contract where that contract is placed with one entity who's responsible for both design and construction. With respect to, do you need a lawyer? Unless it's a very simple tenant build out or just a minor rebuilding project, the answer is yes. And the answer is yes because you want somebody to look at the contracts before you sign them. You want them to be fair and balanced, and you want to make sure that risk isn't placed on you that you shouldn't have, or that you will be burdened by if you're not aware of it. So you want to make sure that you understand what's going into the construction contract, and that's why you would need an experienced construction lawyer to work with you and advise you. How do you select an architect or a contractor? This assumes that you either have the financing in place to go forward with your project, or the insurance coverage has come through to cover the costs of rebuilding. So you've got that in place, and it's important to get that in place before you start talking to contractors. Then you start to, once you understand what your financial wherewithal is to engage in a rebuilding effort, then you start to look for your design professional and your contractor, or your design builder if you're putting it into one contract. You want to make sure that you're hiring credible, reputable people. Unfortunately, when tragedy strikes, out of the woodwork come contractors that are less reputable. And we know from experience, for example, when the tornadoes hit in St. Peter, Minnesota, many, many years ago, many contractors came in from out of state, and unfortunately they took advantage of the homeowners who were desperate to get their homes rebuilt, and took the money, didn't finish the work, or if they finished the work, it was poorly done. So again, don't fall for any pressure tactics. Be careful of scams. This is the time for you to be on guard. You need to make sure that you protect that bucket of money that you've got to rebuild your project, and you're hiring credible contractors. If somebody comes to you and tells you that they'll handle, as a contractor, they'll handle all of the insurance pieces of it if you give them the work, that's a red flag. You need to be careful, because you are guaranteed in most cases to spend more money on that contractor than you would if you had followed a process where you put the project out for a competitive bid. Make sure that with the companies you're looking to hire, that they're licensed to do business in the state of Minnesota. That means they're properly incorporated and they've registered with the Minnesota Secretary of State to do business in the state. That information is available online. That's different than a license to perform the construction work. As I mentioned, commercial general contractors do not need to carry a license in the state of Minnesota for general contracting work, but electrical contractors and plumbers do need that type of license. Depending on the size of your project, you'll want to consider whether the contractor has bonding capacity or capability, and that's a bond that we typically refer to as payment and performance bonds. Payment and performance bond will add about 1.5% to 2% to your construction costs, but it ensures that your subcontractors and your suppliers are getting paid through the payment bond, and that's important to make sure that your project is free from mechanics liens. In other words, you don't want to have to pay twice. You don't want to pay a contractor and then not have the contractor pay its subcontractors or suppliers, and then under the mechanics lien statute in Minnesota, you could be put in a position of having to pay twice. That would be a bad situation for you. A payment bond protects you from that type of risk. A performance bond, on the other hand, protects you as the owner from the contractor not completing the construction work, or if there's deficiencies in the construction work. So that's the performance bond. Ask your contractor, depending on the size of your project, if it's a complete rebuild of any considerable size, whether they have the ability to get bonds in terms of payment and performance bonds. Also, make sure you get at least 3 bids. You want to make sure that your project is competitively bid. It doesn't necessarily mean that you'll award the project to the low bidder. Sometimes that makes sense, sometimes it doesn't. But at least you've got 3 bids to draw comparisons from. Get recommendations from people who you trust. If you do not have experience working with contractors, especially commercial contractors. So you want to get recommendations from people you trust. If you are just cold calling contractors, you want to ask for references and make sure, and in this day and age, it's easy to do a Google search on a contractor and look for any court filings or complaints with the Better Business Bureau. Next slide.
So this is after you've had a couple of bids, you've been able to evaluate it. You really want to look at the quote and or the contract very carefully. Take a look at the fine print, make sure that you are agreeing to pay for services that you've discussed with the contractor, and be very careful if the contractors made certain oral promises that are not in the contract. So make sure it is in writing. So that's very important. And Minnesota law requires that these contracts be reduced to writing. So, and as well as change orders require writing. So just make sure that you read the fine print before you sign. Next slide.
The contents of a written construction contract, should include the top 10 items that Tian discussed previously. But in addition to that, you want to make sure that your contract has a detailed summary of the services the general contractor, the design builder is to perform. You want to make sure that the start and completion dates are included in the contract. You want to ensure that the contract discusses building permits and inspections that are required. You want to make sure that there's a description of the specific materials to be used or a list of standard features to be included. For those of you who are building projects of considerable size and using an architect, the architect is charged with putting those list of specifications together. For those of you who are engaging a smaller project, that's something that typically the general contractor or design builder will put together for you. But you want to make sure that that's all included in the contract so that there are no surprises, or that you think that there's a scope of work that should have been included and your thinking is that it is included, or some materials that were to be provided and then the contractor comes to you later on and says, no, that scope of work isn't in the contract, or those materials are not part of this contract. Again, the purpose of the contract is to give you a source of comfort that there's no gaps in the scope of the work, and that the materials used are to be the materials that you want. So this is your time to get it done and get it done right, so there are no surprises with a contractor coming back to you asking for a change order. And a change order, for those of you who are new to the process, a change order to a construction contract is, in simple terms, an amendment to the construction contract that either adds to or takes away from the contract work, meaning in most cases the contract price. In most cases, a change order adds to the contract price, so it increases the cost of the project. So you want to make sure that there isn't a gap in the scope of work that would trigger a change order that would surprise you. It's one thing for you to say, I want to add granite countertops to your shop, and add that as a change order. It's another thing for a contractor to come back and say, well, you know, what do you mean you thought the granite countertops were included in the scope of the work or the list of materials? I'm giving you Formica. That's what I had in my bid. So you want to eliminate those types of misunderstandings or miscommunications wherever possible. The contract needs to include the price, the total contract price, or the description on how the price will be calculated. There are many ways to price out a construction contract. There's the fixed sum or the lump sum contract, which is I'll do the work for a set amount of money. There is, time and materials, or also known as cost of the work plus a fee. So that means that whatever it costs is what it costs, and then the contractor adds its fee. And that's the least comforting to most owners, because you've essentially handed over a blank check to the contractor, and you have very little control over the amounts that are being charged to you. If you're very comfortable with the contractor that you're choosing and you used them before, or you trust them more than you trust your family members, then you can look at that, because there are some efficiencies. A lump sum contract is a contractor who is going to prepare an estimate, add that up, and then add in what we call a contingency to make sure that if they're wrong, or there's additional items, that they've got that built in. So again, make sure that you understand what you're bargaining for. And the final part of another contract form is a guaranteed maximum price, where it's really the cost of the work plus a fee up to a GMP, a maximum price where the contractor can't exceed that GMP. And if it's less than a GMP, that's to your benefit if the owner, as the owner. Sometimes those savings go 100% to the owner, and sometimes there's a clause in the contract, a shared savings clause, where some of the savings go back to the contractor to give the contractor an incentive to be more efficient and provide the best prices possible. You want to make sure that with respect to any equipment types or any colors or carpet grades, tiles, anything like that, that's specifically set forth in the contracts, or that there's an allowance for, for example, so many dollars per yard for carpet or for tile. You want to make sure that that's covered in the contract. The names of any subcontractors and major material suppliers that the contractor would use. You want a list of those individuals or those companies, so that you're tracking them, so that somebody doesn't show up out of the blue and say, by the way, I'm XYZ subcontractor and your contractor hasn't paid me for the materials I've supplied to this project and the labor I performed, you want to make sure that you understand who's on your project and building your project. Payment and holdback clauses, you want to, to the extent that you want to hold back a certain portion of the contract. 5% is usually the standard and covered by statute in Minnesota. That's what we call a retainage, and the retainage is released at the end of the project. And that gives you some leverage as an owner to make sure that if there's some problems, the contractor will be back to take care of them in terms of some change, some warranty items before final completion, or any corrective work that doesn't fall within the warranty work. So those are the things that you want to make sure in terms of contract contents that are included in your contract.
So next slide. So let's talk about the top 10 negotiated terms in construction agreements. Obviously, the first one is price and payment. Price is very important, right, for the project to be economical and within your budget. You want to make sure that you have a reasonable price, and one of the ways you do that is also having at least 3 bids, as we talked about earlier. There's also payment provisions. When do you pay the contractor? And when are you allowed to withhold payment? So the clause will specify the conditions that are in place for payment as well as withholding payment. Number 2 is we want to talk about precedents and incorporation. So the contract documents can comprise of many different types of documents. There's drawings, there's the contract documents themselves, there's general conditions, and sometimes they may have some inconsistencies in the way a project may be built. So there are rules on precedents on what contract clause takes precedent over another, and that clause will specify the precedents. For example, special conditions may take precedence over general conditions, and so you want to make sure you pay attention to particularly the clauses that take precedence over others. As far as incorporation clauses, they may incorporate other contracts into your contract or other clauses into your contract that's not expressly written in your contract. So you want to make sure you look at those as well, so that you know all the terms of your contract, even though they're not completely spelled out in your contract. They're in your contract by incorporation. There should be a deadline for the project and a schedule for you to keep track of the contractor. Otherwise, the contractor could take their time, and it might take a really long time to finish the project. So a project schedule is very important, and a completion date should be set in the contract. Another clause that is commonly negotiated is the liquidated damages clause. And what that is essentially the parties agree to an amount of damages to compensate the parties if something goes wrong that is reasonable. And typically they would be enforced if the amount is reasonable. But there's certain rules that if the liquidated damages clause is there for punishment or punitive purposes, or they're completely disproportionate to the actual damages that you might incur in a project if something goes wrong, then they may not be enforceable. But that is another clause that is highly negotiated. For example, an example of such a clause is the contractor will pay $5,000 a day for every day that the contractor is late in completing the project. That is an example of a liquidated damages. There's also consequential damages clauses, and sometimes they're referred to as limited liability clauses, and they limit your liability essentially. So for example, consequential damages are indirect damages. They could be lost profits. Let's say the contractor does not complete the project on time. So you're late in opening up your business months, year, and that will impact your profit and your financial projections. So a limitation of liability clause is essentially saying that you could not recover your lost profits if the contractor breached or delayed the project somehow. So be careful with these clauses, and they're enforceable on a case-by-case basis. If it depends so much on the way they're drafted and the circumstances of each case, the court may find that they're ambiguous, but it's really determined on a case-by-case basis. So please be careful with consequential damages and limitations of liabilities. Now, if they're mutual, they're also there to protect you so that the contractor doesn't come back and claim exorbitant amounts of money from the owner for any type of breach or anything that goes wrong during the project. We talked about change orders previously also. They're essentially an amendment to the contract, and they should be in writing. And be careful because the changes typically will add costs to the project. Let's talk about warranty. The contractor should warrant its work and performance of its work, as well as all the equipment that is installed in the project. And the equipment that is installed in the project, the equipment, you should receive warranty manuals, and you should probably keep them in a file. And you should discuss the length of the warranty, and it's typically done at project closeout. There's also notice provisions in the construction contract, and the notice provisions are very important when it comes to enforcement of your rights under the contract. If you do not follow the notice requirements of certain construction contracts, you may foreclose your claim, and you may prevent yourself from being able to prosecute or pursue that claim if the notice provision is not followed. There's also statute of limitations, and basically those are time periods or by which you can bring a claim. And so you want to make sure that if there is a claim, that you provide notice within the time required by the contract, or you bring the claim within the time requirements of the contract. Let's talk about security for the project. So you're in the middle of building this project, and what if it gets damaged by a storm, or there's other acts that could also damage the project? So you want to make sure that you protect and insure against risks for your project. And Jocelyn talked earlier about performance and payment bonds. Recapping, performance bonds essentially protects the owner to ensure that the contractor performs, and payment bonds essentially ensures that the contractor is paying the subcontractors for their work. And so we will also go into more detail about insurance, indemnity, and waiver of subrogation, but it is a commonly negotiated, these are commonly negotiated clauses in construction agreements. And lastly, there's also claims and disputes, dispute resolution clauses. And they also outline the procedure by which you would go in asserting a claim or trying to resolve a dispute. So for example, a claims and dispute resolution clause may require that two senior agents of the companies meet to work out their differences or come to resolution with regard to a dispute. The clause may require that the parties mediate the dispute before pursuing any other litigation type remedies. So you want to make sure that you follow the procedure in the claims and dispute resolution clauses in these contracts. Next slide. So in a nutshell, the best practices in negotiating and working through these construction contracts is you want to revise and review and review very carefully, review the fine print, and you want to make sure that the contract is signed before the work starts. That is very important. So often the parties get very excited about proceeding with the project, and they start building before their corporate entities have even been able to seal the deal and sign the contract. Also take advantage of the free legal resources that are available to you through Legal Corp or through Dorsey. And if there are terms that you don't understand, or there's if you need assistance in reviewing a contract, or you think that you need additional terms included in your contract, feel free to reach out and have someone look at the contract and advise you. And so the contract is really, really important and key in protecting your rights, in getting the rebuild to go as smoothly as possible. So spending some time and making sure that you have a really good contract is really important. Make sure that the architect and the construction forms that you're using have the same dispute resolution forum. So essentially you want the architect, the contractor, the subcontractors all have the same type of dispute resolution forum. So for example, if there is a dispute, the forum needs to be Minnesota or Hennepin County, or depending on where the project specifically is, and what location is advantageous to you. That's another thing to consider. But you want to make sure that everybody has the same forum, so you're all in the same vicinity, so that there isn't different lawsuits at various different parts of the country over the same project. Make sure that your architect and your contractor procure the required insurance as promised under the contract. And then you also want to understand the notice requirements of your contract and follow them, as we discussed previously. If you don't follow the notice requirements of the contract, you could be jeopardizing your right to enforce the contract and pursue any claims that you may have against the contractor. Make sure that when you accept work, that you are accepting conforming work, that you're not accepting non-conforming work. So make sure that you understand what you're accepting before you accept it. If work does not pass inspection with the building inspector, if there's other issues that come up, you are not obligated to accept the work. This may be a dispute. This is maybe something that needs to be worked out and discussed amongst the parties and with the contractor. And lastly, the most important idea to take away from this is a fair contract is a good contract where everybody wins. So as much as you want to protect yourself, you don't want to be completely unreasonable, because you want to make sure that you have a fair contract and that both sides have an agreement that will provide the best project and the best price for both parties.
With respect to Tian's comment that a fair contract is a good contract, what you want to do is, if you think about what is the purpose of a contract, a purpose of a contract is to allocate risks, especially on a construction project. So when we say a fair contract is a good contract, a fair contract that allocates risks appropriately, so the risk the contractor should be taking on versus you, and then the risk that you should be taking on versus the contractor. Those are all a reasonable allocation of risks, and assuming that the allocation is reasonable and fair, that's a good contract. An onerous contract where it's truly one-sided for either the owner or for the general contractor, in my 28 years of practicing construction law, generally onerous contracts lead to claims and litigation, which is not where you want to go with your rebuilding project. Next slide. What type of construction contract should you use? The general contractor or the design builder may come to you with their own contract that they've prepared and put together. I call that a manuscript contract. Or they may come to you with a standard form contract. Commonly what's used in this area are the AIA suite of contract forms, and the AIA stands for American Institute of Architects. The AIA suite of contract forms have been prepared by the architects for use by owners, contractors, and others. If you've got any sizable project, I would recommend that you use an AIA contract form for your project. And the reason that I recommend that is because you don't have to reinvent the wheel. The provisions in the AIA contract are standard. There are court cases that have interpreted each of those provisions, or at least most of them. And so they're a contract form that's been well thought out. Not necessarily always to your advantage. They are prepared by architects, so they do tend to favor the party who has drafted them, which are architects. That said, they are standard and they should be modified if you use them. For example, the AIA suite of contract forms lack adequate insurance requirements to protect the project owner. The insurance that's addressed in the AIA contract forms is usually found in a separate document called the General Conditions, the AIA 201 form, and it's got a few provisions with respect to insurance. That's not enough to address an owner's insurance requirements on a decent sized project, so they need to be modified. There's other provisions in that contract that need to be modified as well. As Tien said, the consequential damages, for example, the AIA forms contain a provision where there's a mutual release of consequential damages. So there's other pieces with respect to notice. You know, we talked about change orders. The AIA documents discuss change orders, and they discuss what the procedure for change orders. You want to make sure as an owner that you modify the AIA contract so to include language that no work should go forward, change order work should go forward unless you've actually approved the work through a signed change order. So again, different parts of the AIA contract to keep in mind, those top 10 contract terms that should be negotiated, all of those terms are in the AIA contract, and some of those need to be modified to make sure that there's a fair allocation of risk between you and the contractor. Next slide.
So let's talk about flow down provisions. And what are they? Flow down provisions are clauses that make the obligations of the general contractor also the obligations of the subcontractor and suppliers. So you want to make sure that your agreement with the general contractor also applies and flows down to the subcontractor and suppliers. One of the ways you do that is you put it in the contract. And so if the general contractor does not flow down your provisions in the contract with the subcontractor supplier, that would be in breach of contract. So Jocelyn, what is your experience? How do you, what else can you do besides putting in the contract to make sure that the general contractor is flowing down the requirements to the subcontractor and suppliers?
That's a good question, Tien. You could, as an owner, require the general contractor to show you its form subcontract so that you can look at the form subcontract to make sure that it includes the flow down provision. And that provision, again, would be very simply that any relevant provisions in the general contract or the design build contract with the owner that apply to the subcontractor flow down to the subcontractor in terms of responsibility. You could take a look at that subcontract form. The time to make sure that that's done right is before you sign your contract with the general contractor or the design builder. So that's where you've got the most leverage to ask to see that form afterwards. After you've signed the general contractor, I recommend doing that. But again, you want to see the form, and then you want to do the follow-up after you've signed and the subcontracts have been signed to make sure that that flow down clause is actually in your subcontracts. And the reason that you want to do that is because there's insurance provisions that should flow down to your subcontractors, and that they have to provide certain amounts of insurance coverage. And so in the event that your contractor, your design builder, didn't have insurance that applied, there may be coverage that comes from a subcontractor. So again, you're trying to make sure the risks are properly allocated and that you're getting what we call the benefit of your bargain, which is making sure that your subcontractors, number one, are paying their bills so that you don't have payment claims made against your project, and two, insurance issues and notice issues, claims issues. For example, the dispute provision, we want to make sure that if, for example, there was an arbitration provision in your contract with the general contractor, that arbitration provision flows down to the subcontracts as well. So those are additional measures and protective measures you can take as an owner. Next slide. Insurance. When it comes to construction projects, especially sizable construction projects, insurance is a key part of the negotiations that occur between a contractor and an owner. You should make sure that you share a draft of the insurance or the construction contract and what the contractor has offered you in terms of insurance coverages with your insurance broker, to make sure that your insurance broker is comfortable with the provisions. Depending on the size of the project, you might have an all risk, a builder's risk insurance policy in place, and that policy is designed to cover the project under construction. For example, during the rioting, there was a 6-story apartment project that was under construction, and that project was subject to a fire. The all risk builder's risk policy that would have been in place would provide coverage for the losses sustained from the fire during construction. So it's a very important policy, and either the owner can carry that policy or the general contractor design builder. So you want to have a discussion with your insurance broker, because sometimes you can purchase that policy for a lower cost than a design builder general contractor offers it to you. So that's important. And then other insurance considerations, specifically on construction projects, are what we call our commercial general liability coverage. And the most important coverage in most cases for you as an owner is what we call completed operations coverage that comes as part of the commercial general liability policy. And what completed operations coverage means is that's the coverage that's in place after construction is completed. So for example, if there's a defect that occurs, I'll say 5 years after construction completion, and I'll give you an example. Let's say your curtain wall, your windows start to leak because they weren't installed correctly, causing water damage. And then that in turn damages, wall board, rugs, even merchandise or other equipment. You would make a claim against the general contractor, and it would be the general contractor's commercial general liability completed operations that would hopefully kick in to provide you with the coverage to correct that damage and put the work back in place the way it should have been constructed originally. And so that's the benefit that you get for it. Typically what you'll see is in an insurance provisions in a construction contract, you'll generally on more modest sized projects, you'll see a requirement of $2 million per occurrence of CGL coverage, the commercial general liability coverage, with an umbrella policy or an excess policy on top of it of anywhere from 3 to 5 million. You want to make sure that you're requiring that second layer of insurance coverage, because the last thing you want to have is an insured loss occur and there's not enough insurance in place to put you back in the position you would have been in but for the loss. So you also want to make sure, as we talked about earlier in that flow down clause, that the insurance requirements flow down to the subcontractor. And usually the insurance required of a subcontractor is a little less than the insurance you would require from your general contractor. So maybe about $1 million worth of coverage. As I talked about earlier, you wanted to make the decision whether or not you want to require payment and performance bonds, which generally cover 1 to 1.5% of project costs. Next slide. Very quickly, the additional insurance considerations, Tian.
Yes, some of the additional things you want to consider are possibly automobile coverage. For example, if there's equipment that's coming in, or you want to make sure that the owner is listed on the as an additional insured on the contractor's automobile policy. There's also workman's compensation consideration, professional liability, and pollution liability. For example, if you come across asbestos or anything, if you're remodeling or renovating or adding to a building, those are some of the things to consider. As far as the owner's professional protective indemnification, those are more OSIPs or CSIPs. They're typically more needed in larger projects. Next slide.
With respect to other considerations, the AIA forms typically have a waiver of subrogation claim. You want to make sure that that waiver of subrogation provision is acceptable to you. It's found multiple times in the AIA contracts. And then you want to give some thought to that, and to the extent that you don't have experience with waiver of subrogation claims, again, that is something where it's beneficial to have that discussion with a construction lawyer who can advise you and modify the clauses within the AIA to the extent necessary. The larger message here is make sure that you're teaming with professionals. Make sure that you get the contract document right. And if you get the contract document right and you've chosen the right contractor, the goal is that you shouldn't ever have to go back and look at the construction contract. But the construction contract is important, because if you've got issues on your project, whether it's payment issues, change order issues, insurance issues, claims issues of any type, that contract is there to provide you guidance. It is your playbook in terms of your project, and you want to make sure that you're comfortable with it and that you understand it. And again, there is no one size fits all contract, especially when we're talking about commercial projects. You want to make sure that it's your project, that this contract is modified to protect and give you a proper allocation of risk. Next slide.
We talked about warranties earlier before, and it's really important to make sure that the contractor warrants the quality of its work, and of course all the equipment and that is installed in the project. And you can just collect a lot of the warranty manuals in a file, and to make sure that you are protected if anything goes wrong with the work that has been performed. Next slide. Payment.
As an owner contracting to have a project built, obviously you're going to have some payment obligations. That said, you want to make sure that you're getting the proper amount of protection when you make those payments. As an owner, do not make the payments unless you're getting a mechanics lien waiver in exchange for those payments. Every payment that you make should come with a mechanics lien waiver form. And the reason that's so important is, Minnesota law by statute has a mechanics lien statute. And that mechanics lien statute is in place to make sure that subcontractors, suppliers, people who build your project, the laborers, that they're all getting paid. And to the extent that they're not getting paid, they can file a lien, a mechanics lien, against your project, against the property. And that could be a problem for you if you paid the general or the design builder and that contractor has not paid its subcontractors or suppliers. You could be in a position where you have to pay twice. That's why you want to make sure that you're getting partial mechanics lien waivers for every payment that you make of any size on your project. And you also want to make sure that that mechanics lien waiver form is well written. Some of those mechanics lien waiver forms that are presented by contractors that they write have carve-outs that don't provide you as an owner with any meaningful protection given the payments you've made. So you've got to pay attention to the mechanics lien forms language as well. If a contractor or a supplier reaches out to you directly for payment, that's usually a red flag. It means that they're not getting paid or there's some type of dispute between the supplier or the sub and the contractor, the general contractor, design builder you've hired. There may be a legitimate dispute. For example, the subcontractor may not be staffing the project appropriately or may have overbilled on its last invoice. In contrast, the dispute may be that the sub or the supplier is just not getting paid and they're not going to do any more work on your project and they want you to pay them. So you need to be aware of those calls and take them seriously and reach out to construction counsel to work with you. Minnesota's mechanics lien law does allow an owner to pay a subcontractor directly to the extent that they've filed a lien on a project. But again, you want to make sure that you don't put yourself in the situation where you may have to pay twice. Again, monitor the payments carefully. That's one of your most important jobs as the owner. And it doesn't mean to be unreasonable and not make the payments, but it does mean what you want to do is make sure that your payments are going where they're supposed to go and that you're not being exposed to the possibility of paying twice. And I know I've said that repeatedly now, but those are the parade of horribles that come back to owners most of the time on projects when there's problems. So you want to make sure there's no problems. There are cases where you could write what's called a joint check. Again, under the Minnesota mechanics lien law, where there's a mechanics lien against your property from a subcontractor, you could write a check and you could make it out to both the general contractor and the liening subcontractor. That's what we call a joint check, and that's allowed under Minnesota mechanics lien. There are certain circumstances where you have a right to withhold payment as well. Again, you need to make sure that you're being reasonable here and that you have the right to withhold the payment for the reason you're doing so under the contract. Next slide. I've covered mechanics lien. The one issue and why this slide is here is what I want to cover is a pre-lien notice. A pre-lien notice is separate than a mechanics lien being filed against your property. Under Minnesota's mechanics lien statute, for projects that are 5,000 square feet or less, there's a requirement for a pre-lien notice. And the pre-lien notice can either be incorporated into the actual contract with you and the general contractor, or if it's the general contractor is contracting with subs or suppliers, they can either deliver to you personally or by certified mail a mechanics lien pre-lien notice. And that notice has to, the form of it has to follow the statute in Minnesota. So if that arrives in the mail within 10 days of a subcontractor starting work on your project, that's what it is. It's the pre-lien notice. It doesn't mean that they filed a lien against your property. Next slide. That brings us to the end of our presentation today. We hope this has been helpful. It hasn't been the entire encyclopedia of construction contracting law. The presentation has been intended to give you a basic nuts and bolts understanding of things that you should be looking for as you move to reconstruct. And we're here to help you. And I believe Elisa is going to explain exactly what Legal Corps and the pro bono effort available to you is. Elisa?
Thanks so much, Jocelyn and Tien. Very good presentation. And this does mark our last presentation in the webinar series. For those who saw our original invitation, we had been planning to do a session tomorrow as a wrap up and a kind of a Q&A session, but we have canceled that because we've learned that a lot of people will be honoring the holiday of Juneteenth tomorrow, and we also want to honor that. And so we're not doing that session, but that doesn't mean we're not available to you for that same purpose. And so we really do encourage people to reach out to us through an email, get in touch with me. This last slide does include my contact information as well as Jocelyn and Tien's. And we have sent out PowerPoints from each day's presentations and really do welcome you to reach out to us individually. Also, you can call the intake line for Legal Corps, and they can do a complete intake to meet your needs if they're not related just to the issues of rebuilding. Legal Corps is able to connect you with volunteer lawyers that can help you with other transactional business needs as well. And so we hope you'll take advantage of that. We will be sending out an email to everyone that's on our registration list to let you know when the videos and the PowerPoints are available to be linked through the Legal Corps website. And we hope that your rebuild process goes smoothly, and we want you to know that you're not on your own. So thank you so much for joining us.